Okay. I move for a vote of no confidence in Joshua Warren as chairman of the Kingston's Board of Selectmen, and that he be removed from his position as the chairman of this board.
Can I get a second?
I'm going to second for discussion because I'm intrigued.
I have a prepared statement that I hope that I can read uninterrupted, and bear with me because this is hard for me. This motion is not something that comes easy, and I want to make it clear that I'm doing this as a last resort. I only ask that my fellow board members hear me out and give me fair consideration. Josh, if at any time during this statement you want to voluntarily step down as chair, I will simply let me know, and I will stop my testimony and withdraw my motion. I have had ongoing concerns since September about Josh Warren's ability to fulfill his duties as chairman. I believe he has promoted a divisive environment on the Board of Selectmen and has allowed for hostility to fester. He has been punitive, undermining, and condescending to me, refusing to speak to me, and denying my requests to clear the air. But what has brought me to the point where I am calling for a vote of no confidence is his specific actions since last Friday, January 10th, which I feel have not been in the best interest of this board or the town of Kingston. The testimony I'm about to give references a complaint I filed, but I will not be discussing the details of that complaint or naming any of the parties involved. My testimony is specifically about Mr. Warren's actions and leadership in the wake of my complaint. If, during my testimony, I speak the word redacted, that is because I am omitting specific texts from referenced documents in order to protect the details and identities of those involved in said complaint. I reported an incident involving a fellow Kingston employee immediately following that incident last Thursday night. On Friday morning, I formalized my complaint and requested immediate action be taken. That very same morning, it was explained to me by Labor Council that, due to the nature of my complaint, they were recommending the board enter into an executive session to vote on the following two items. 1, an independent investigation, and 2, that the person named in my complaint be put on paid administrative leave during that investigation. When I questioned why this wasn't happening right away, it was explained to me that such action has to happen in executive session, and under MGL 30A Section 21A1, the person being discussed had the right to 48 hours notice. I was assured that an executive session would take place this Wednesday or Thursday to vote on the motion suggested by Labor Council, and that the person named in my complaint would voluntarily stay away from Town Hall until said executive session could take place. I was told to trust the process. On Monday, January 13th, I heard that the person named in my complaint was not staying away from Town Hall as committed. I made a plea to Labor Council expressing my ongoing fear and concerns for the safety of others. I hoped my board's leadership would be compelled to do the right thing and to stick to the process and commitments that were made on Friday under the advice of Labor Council. I heard nothing for most of the day. The stress of the situation was making me physically ill. At 4:35, I received my first and only phone call from Josh Warren on the matter of my complaint. It had been the first and only phone call I had received from Josh in months, so it was a noteworthy occasion. When I received his incoming call, I was not alone, nor did I represent that I was. So my side of the conversation was witnessed and is verifiable. Furthermore, that night, I documented the content of that call and shared it in an email with Mr. Warren in order to give him the opportunity to correct my understanding of the facts. He has yet to contest any of the facts outlined in my email documentation of the content of the call. To summarize the content of Monday night's call, Josh informed me that a counterclaim had been filed against me that day. There were two reasons that would be listed on an agenda for an executive session to occur at 5 p.m. Thursday. One was to discuss the claim I made. The other was to discuss the new counterclaim against me. I asked to see the complaint against me, and Josh said no. With regards to my complaint, Josh stated that he requested that the board be given the option to have an internal investigation into the matter. I strongly objected, saying that an independent external investigation had been council's recommendation from the beginning, and that I believe an independent investigation was necessary and appropriate. Josh said he disagreed and thought it should be handled internally. He said it would, quote, save the taxpayers' money. Despite having not witnessed the incident in question, Josh stated on more than once during the call that it was my actions on the night of the incident that were, quote, totally inappropriate. With regards to the accusations against me, Josh told me that my name would be listed on a publicly posted agenda, along with the executive session purpose of discussing my, quote, reputation, character, physical condition, or mental health. Josh then asked me if I had seen the executive session agenda that was currently posted for the Board of Assessors meeting Wednesday morning regarding Dan Harlow. I said I had. Josh explained the exact same verbiage regarding my, quote, reputation, character, physical condition, or mental health would be used, with my name explicitly stated on a publicly posted agenda. Josh went on to say that the agenda had to go up by 4 p.m. Tuesday, the following day. Josh said that a public posting of this nature could potentially harm my professional reputation, and he felt it appropriate to give me a heads up in case I wanted to reconsider. He then stated I had until 4:30 tomorrow, quote, until 4:30 tomorrow before it goes public. At the end of the call, I processed what I had just been told. I processed the news that what I contend is a retaliatory and unfounded counterclaim against me had been filed days after the incident. And I processed my feelings that the true intent of the call from Josh was to get me to back off my complaint, or at the very least, allow it to be handled internally. There was no doubt in my mind that the discussion of the planned agenda posting, his reference to the, at that time, still active scheduled agenda posting about Dan Harlow, and comments about how a publicly posted agenda naming me in such a manner could potentially harm my professional reputation, and the timeline to think it over had all been an attempt to intimidate me and second-guess my desire to move forward with my complaint. It was reasonable to believe that the person named in my complaint would be very uncomfortable and embarrassed to have his name listed on a posted agenda in such a manner. And it seemed that the intimidating call I had just received was an attempt to prevent that from happening. Although I was unsure if it was even proper protocol to list an individual's name on such an agenda posting, the town had created a clear precedent for such a disclosure with the still active Board of Assessors agenda stating Dan Harlow's name. It seemed that this was being used as a tactic to embarrass and discredit people. And now, due to the posting requirements necessary for conducting executive session, coupled with the active precedent of name disclosure, it seemed the person in my complaint was going to become a victim of this tactic. And it was clear that Josh wanted to protect this person from that embarrassment. Shortly after the call ended, while I was pondering the reference to Dan Harlow and the intimidating comments about the pending agenda posting listing my name, it struck me. Dan Harlow had announced earlier that day that he was asserting his right to have the discussion regarding him take place in open session. I would do the same. I would be glad for the opportunity to discuss the retaliatory claim against me. It was clear that the person named in my complaint was going to great lengths to prevent public disclosure of his name, and Josh was going to great lengths to protect him. So I was going to call his bluff. I called Josh back and left a voicemail stating that I wanted the discussion regarding the claims against me, where I was going to be named publicly on the agenda, to be aired in open session. I followed up with an email. I figured that since it was clear that Josh was protecting the identity of the accused, maybe the retaliatory counterclaim would be dropped to avoid the public airing of dirty laundry. Keep in mind, this was all Monday night. The agenda naming Dan Harlow was still active. I knew that the town was between a rock and a hard place. They would have to disclose the name of the person named in my complaint in a similar manner on the agenda, and they would and if they choose to name me on the agenda as well, I was going to evoke my right to an open session. I was shocked to hear via an online post that on Tuesday morning, following this call, Dan Harlow had received an email that the scheduled executive session in which he had been named on the agenda had been canceled. Instead, he was to have a private meeting, and not with the chair of his board, but with the Selectman Chairman Josh Warren, who does not and should not have anything to do with the Board of Assessors and has no authority to act on their behalf in discussing any of the reasons listed in the posted executive session reading. For the sake of clarification, here's exactly how the agenda posting read, and I quote, "To discuss the reputation, character, physical condition, or mental health, rather than professional competence of an individual, or to discuss the discipline or dismissal of, or complaint or charges brought against a public officer, employee, staff member, or individual, to wit, Daniel J. Harlow, member, Board of Assessors." End quote. There was no doubt in my mind that this unexpected change of course was directly tied to the events the previous evening. Josh's attempt to intimidate me had backfired. It was clear that I had pulled a page from, it was clear to them I had pulled a page from Dan Harlow's playbook, and that the scheduled Wednesday morning meeting to discuss him in open session would only set further precedent of the rights of the accused and how the town dealt with these types of matters. So now, instead of the Board of Assessors meeting regarding Dan Harlow's proceedings as scheduled, Dan Harlow was being told to meet with Josh Warren. After this news Tuesday morning, I tried to let the day proceed as scheduled. I fully anticipated an executive session agenda from the Board of Selectmen to be posted that evening at 4:30. The time Josh had stressed to me was when my name would, quote, "go public," and my professional reputation could be jeopardized. I had requested an open session, so I clearly wasn't falling victim to the intimidation. To be frank, I suspected that the retaliatory and unfounded counterclaim against me was simply going to be dropped. I then found out that despite the promise made to me on Friday, the person who had filed the claim against me had been in town hall again on Tuesday morning. That afternoon, while anticipating the promised BOS executive session meeting notice be posted at 4:30, I felt compelled to explicitly express my ongoing concern to the board chairman, Josh Warren. At 3:38 p.m., I sent Josh the following email under the subject line, "Work Environment." "Hello, Josh. The purpose of this email is to make clear that I feel intimidated and fearful of going to town hall or performing my duties as selectman. I am a female who filed a credible and verifiable complaint involving redacted. Since my complaint, I feel nothing has been done to address my concerns or make me feel safe. Rather, the perpetrator, redacted, is being protected, while I am being gaslighted, retaliated against, and pressured to back down. I respect the need for due process, but total disregard for my safety and well-being, as well as the safety and well-being of others, is unacceptable. I understand the rights of the accused for 48-hour notice, with respect to an executive session under MGL 30A, Section 21A1. But on Friday, when I expressed my ongoing fear of aggression and retaliation against me, I was assured redacted would not be in town hall leading up to the executive session to discuss my complaint. This is not true. Redacted was in town hall both yesterday and this morning. This is a hostile environment and nothing has been done to address it. Regarding my complaint, the only communication I received from you, Josh, other than emails of an administrative nature, was a phone call last night. The details of this phone call have been outlined in the previous email, and I want to be clear on how that call came across. I felt like retaliatory victim shaming designed to shift the blame and deter me from moving forward with the complaint. I want to make sure there is no confusion. I am scared to enter town hall. I am concerned for the safety of others, particularly female town employees. Redacted paragraph. At this point, nothing has been done, other than the promise of a meeting Thursday at 5, which has yet to be posted, and which you made clear would be posted naming me, my reputation, mental health, etc., as one of the individuals being discussed. You also made it clear that you had requested the option of an internal investigation to be voted on, rather than an independent investigation to address my very serious complaint. This is all so very punitive. This is not how you protect victims, and this is not how you lead through conflict. Paragraph redacted, signed Jess. Following this very serious email explicitly outlining my concerns, I received an email from Town Council on which you were all copied, stating that despite the promises and despite my pleas that my complaint be taken seriously, our chair, Josh Warren, had decided not to have an executive session. Instead, we were to have this open meeting where neither the complaint nor the counter-complaint could be discussed. I firmly believe the only reason Josh opted for an open session under these stipulations was to protect the name in my complaint from public embarrassment and of his name being posted on executive session agenda in the exact same manner in which Dan Harlow's name had been used in order to inflict humiliation upon him. Because of Josh's decision to protect the accused, we are not allowed to address Labor Council's recommendation to put the person named in my complaint on paid administrative leave during the investigation. As such, a motion can only be addressed in executive session and only after giving 48 hours of notice to the accused. Josh is well aware of the reasons for my concerns, yet he chose to protect the ego of the accused over the safety and well-being of the employees at Town Hall. This is not the first time a complaint of this nature has been filed against the person named in my complaint. There is a clear precedent in this town for placing employees on paid administrative leave while complaints of this nature are investigated. It is standard practice, and it was the recommendation of Labor Council. There was a delay in holding this meeting to allow for adequate time to post and give notice of the executive session in order to vote on paid administrative leave as prescribed by Labor Council. We, as selectmen, have a duty to keep employees safe while the investigation is performed. Josh, as our leader, took actions that prevented us from taking a necessary vote to ensure their safety. I am an elected leader of this community, and I deserve to have my complaint and my concerns taken seriously. I deserve protection against retaliation and intimidation. Josh should have allowed for the process to go in accordance with recommendations made by Labor Council on Friday. Josh should never have strayed from the prescribed process in an attempt to protect the accused. Josh should never have allowed for the accused to go back onto the premises to go back on his promise to stay away from Town Hall. Josh should have given me the respect and decency I deserve by taking my complaint seriously. Josh should never have tried to intimidate me into not proceeding with my complaint. Josh should never have expressed the opinion that I, the complainant, am the one who, quote, acted inappropriately. Josh should never have pushed for the complaint to be handled, quote, handled internally. Josh should have been acting in the best interest of this town. All I ask is that my colleagues on the Board of Selectmen consider my testimony. I am speaking for every victim whose claims have been diminished, for every whistleblower who has been retaliated against, and for every person who has been made to feel intimidated after filing a claim. If, after an independent investigation, there is any question as to the legitimacy of my complaint, I would, of course, need to answer for that. But for now, the truth needs to come forward through an independent investigation process. And based on Josh Warren's actions in the wake of my complaint, I don't trust that a truly impartial process can be undertaken with him seated as the chairman of the Board of Selectmen. So, I beg of you, for the good of this community, please vote to remove Josh Warren as our board's chairman, if not permanently, at least for the course of this investigation.
So there's a motion on the table.
Mr. Chairman, can I address some of the points raised?
Chairman, Elaine gave the council a note during that
So,
testimony.
Mrs. Sherman,
Allowed to be shared with everyone.
Mrs. Sherman, there's a motion.
I believe it is.
There's a motion on the table. Do I have a second?
Second.
She can't be passing notes in the public section. She has to respond.
To remove me from chair?
I believe that has to be
I
read.
had seconded it for discussion.
Those are public documents.
Those are public documents. What's Slino, they need to be.
John.
Council should advise you.
I will address issues raised by the board. And the board is not,
Can you please tell me what was passed during the meeting?
I'm sorry, what was that?
You said that the board can, you can address my question if the board raises it, so I would like to know what the note passed during the meeting was.
Certainly, Mrs. Fiore asked me if I could speak to this issue, and I had intended to speak to the issue. It is always, and I want to speak generally about these kinds of situations without addressing this particular situation, because as we've discussed through emails and in phone calls, there are rights of individual officials and employees involved, and those rights have to be respected. And the downside of not respecting those rights is exposing the town to litigation. In this particular case,
Excuse me.
in this,
Can't continue the meeting. We're gonna have to clear the room.
in this particular case, in this particular case, it was Labor Council's recommendation to convene an executive session for really the simple matter of doing an investigation and to consider whether anybody needs to be put on paid administrative leave. That is absolutely a discussion that should be held in executive session. That was our recommendation. We were notified by Ms. Kramer that she wanted to do it in open session. Therefore, our advice changed in terms of how to proceed with this. This board has to protect the rights of all employees, of all officials. The result of not doing that is obviously significant financial consequences. Therefore, once it was stated that you wanted to have the meeting in public, our recommendation was vote up or down to hire an investigator. At that point, it was too late to give notice to do anything else, the 48-hour notice to do anything else. That's fine. But that is why our recommendation changed. I will also say that in these kinds of situations, the board, this board and other boards that have faced this kind of situation are in a completely untenable situation. They do not have the facts. There has been no investigation. They don't know what happened. Their priority from the beginning of this, and I've been in regular conversations with every member of this board, my partner's been in conversations with you, Jess, constantly, to try to make sure to work through what is undoubtedly a very difficult situation. But our interests are not served by airing this out publicly. That's what we're trying to avoid. Once the facts are out, it does become public. But until such time as the investigation is completed or there's some other way of working it out, it doesn't make any sense to air it out in a public meeting. That's the only reason why our recommendation changed. We have no expectation that we're going to be able to prevent the identities of those involved from getting out. It's just the nature of the kind of work we do. But for this board to hold a meeting and talk about any individual and possibly diminish their rights, adversely impacting them, again, we're opening the town up to litigation. That's all we're trying to avoid. And my advice to Josh to change the agenda was based completely on that.
In an email you sent, it was stated that Josh made the decision to do that, and also had no intention of ever bringing, the complaints that I made could be aired privately, but any retaliatory complaint against me is either, if they're going to state my name, it was posed to me in a threatening way that my name and my reputation could be at risk, my name was going to be explicitly stated on the agenda. If that was going to happen, I wanted to be able to respond to that publicly. Even in the email that was sent out subsequent to that, it was still reiterated that your recommendation stood that there should be a vote, two votes in my original complaint, one for in independent investigation and one for paid administrative leave. Any counter complaint against me, there were no motions to be made. If anything, that could be considered possibly a defense against my complaint. So I do not understand. There could have been the choice to not move forward at any time with that subsequent retaliatory complaint, and we still could have entered into executive session to take the proper steps to do the process that was outlined when I filed my complaint. So I don't understand.
In a situation where there are cross complaints against two individuals, neither this board or any board has no basis for evaluating the validity of either until an investigation is done. So they can't treat your complaint with more validity, more weight than the complaint filed by another person. That would be a potential violation of that person's rights.
And I'm absolutely not requesting that that happen. All I am simply saying is that there were no votes to be taken on any complaint against me. I had no idea why that had to even be on the agenda. There were required votes based on best practice and your recommendation that had to happen. Again, people's safety, I firmly believe safety was at risk, and that was avoided by doing this. So you say we shouldn't air things publicly, but here we are in a public meeting. I wanted to follow the process and have an executive session to take very serious votes on a very serious accusation. It's not lost on me that I opposed a serious accusation, and I do believe in due process, and I do believe in the rights of the accused. I was trying to respect that, and I had a purely retaliatory complaint filed against me, and I am confident that this independent investigation will show. And to that, regardless of why you say the course may have changed, I still contend that any request for mediation or an internal investigation is ridiculous in this circumstance. This matter is very serious, and there should be an independent investigation done externally. And I do not have any faith that that can happen with Josh Warren sitting as chair.
One other point. There's been a number of references to language that have been in the postings of this or other meetings. The language that we have to give notice to people for an executive session is statutory. There is no It's a purely statutory cut and paste. So that's where the language comes from.
Understandable.
So
And accepted.
there's nothing, there's no intent to be found in this posting or any other. We cut and paste what the statute tells us. I'm sure you've learned from your time on the board, the open meeting law is very technical, and we have to be very precise in terms of how we post things. That's all. There is no hidden meaning or anything else. If this board or any other board is going to talk about complaints or charges against any other person, they're entitled to that statutory notice.
Absolutely, I don't contest that. But I'm just responding to what was, I don't contest that, but the fact, it is my understanding now, in hindsight, that a name does not explicitly have to be disclosed at that time. It was posed to me in my call with Mr. Warren that this would be something that would embarrass someone or make them uncomfortable. I fully contend that again, the statutory language, that's no one's fault, was used as a tool against me to try and get me to back down and put my reputation at risk. I gave Mr. Warren a chance to respond to my statement of the facts and my feelings about that call. He has yet to contest anything that was said on that call.
Mr. Chairman, we have a motion on the table. We have a second. We respectfully listen to the Ms. Kramer's letter So I, please ask that we follow through and vote on this motion.
So we have a second on the table. All those in favor of me stepping down as chair?
Do you have anything to say I didn't know that that was that many pages, but do you have
No,
anything
I
to
mean,
say to
I-
it? Like, there's,
I thought this would be a relatively fast meeting, given the agenda that's here. I mean, for the purpose of tonight's vote, I'm not interested in the details of the event. I want to know everything that happened, and I don't think that we're going to get that without going through these two items. So with that, all the,
Can I ask a technical question?
I mean, I'd rather just take the vote and continue
Well,
going.
with open meeting law, would that motion have to be on the agenda?
I was told that it's I don't want to speak for the procedural type thing. How do you exactly ask a chair to be put on the agenda to make a motion of no contest? And that it's based upon the items, the items that are on the agenda, and that as long as there's no motion on the table, which there wasn't, I have every right to make that motion. As long as it's seconded, I have the floor, I have the right to the floor first, and all of that had proceeded as my understanding of my rights, so.
Okay, is that correct?
Well, I'm with Josh. Let's just take the vote.
So all those in favor?
Aye.
All those opposed?
No. Okay, I move to,
I do appreciate the votes of confidence. You know, I
So,
like to move on to the next item.
I move to appoint an independent investigator for confidential personnel matter.
second.
All those in favor?
aye.
I motion to adjourn.
Can I get a second?
Wait, what was the result of that? Was that, everybody said aye?
Everybody, aye.
Okay, sorry, I missed it.
Motion-
So you'd rather protect
Motion to
Josh's
adjourn.
chairmanship than have a truly independent investigation? That's all I'm asking for. As I said in my
Motion to adjourn.
statement,
Wait,
that,
I don't think we voted on the first one,
Yeah, we vote.
We did.
the mediator facilitator.
Okay.
as I said in my statement, just for
I
the
move
duration of
to-
the investigation, I feel that there could not be independence if Josh is sitting as chair.
We'll do the first one then.
I move to appoint a mediator facilitator to assist the Board of Selectmen and Town Administrator.
Second.
All those in favor?
No.
Aye. Okay, so we've, so with
3 to
that,
2, no, I don't,
okay, so, motion to adjourn.
FOIA request for the
Can I get a second?
Second.
during the,
All those in favor?
Aye.
during the
Aye.
meeting, the public access filing. Can we please make a public copy of that?